Section 1. And the big idea here is how the judicial branch of the government is charged with interpreting the law. Specifically, we'll be looking at civil cases. Terms that we'll be seeing are complaint. That is the legal term used for when a civil case is being filed. Summons. That is when someone in a suit shows up at your house and serves you papers. You are now summoned to court. Discovery, which is the process of figuring out what happened in the roommate not paying their rent case. And then finally, settlement, what needs to be done. So if you're a fan of Judge Judy, hopefully you'll enjoy today's lesson. So again, some other terms you'll see: file, retain, respond, other legal terms related to civil case. So the first question is, do you think settling a civil lawsuit out of court is better than going to trial? I mean, most of us would prefer to not go to trial and would prefer to settle things out of the courts, but unfortunately, in the world we live in, it doesn't always work that way, so we need to learn about how the courts work. Okay, so what is a civil lawsuit? These can involve property disputes. That is, somebody's putting stuff on what you think is your property. Breach of contract, for example, not paying your rent. Family matters like a divorce or even personal injuries. So all kinds of fun, complicated, and examples for you today. So when the case is going to court, your roommate's not going to pay the rent and they're not going to move out. You can't physically make them. They're bigger than you. So now it's going to court. You are the plaintiff. You have claimed to suffer a loss. In this case, you don't have any money because you're having to pay rent for both parties. You're going to seek damages. In the case of the roommate, you just want them to pay their part of the rent. Or if this has gone on for a while, you want them to pay what they owe you and to leave. And so you're seeking damages. In the case of personal injury, it may be that someone harms you. When I was in high school, I accidentally closed a door on a girl. I broke her fingers. I really didn't mean to, but it happened. Thankfully, she forgave me, but had she not, that could have been a civil case. In the case of closing the door, it's going to be me. And I had no grounds to argue it didn't occur because there were many witnesses, and I wasn't going to try to lie about it. It happened. But the defendant, if it goes to court, might try to argue that either this did not occur or that the defendant was not responsible. So maybe I want to argue that, well, she shouldn't have had her fingers there. The door was closing. Not my problem. If I'd gone there, whatever. Or maybe the roommate wants to claim that he did actually pay you. Prove that I didn't. Good luck with that, right? Okay, so civil lawsuits might involve property disputes. That is, someone's planting bushes on your yard. It could involve a breach of contract, like the rent situation. It could even involve family matters, like custody cases. If you're going through a divorce and you're seeking custody for your child, that's not a criminal case, that's a civil matter. It can involve negligence or personal injury. For example, if someone is injured or killed, let's say that you're driving a vehicle legally, you're following all traffic laws, and you're not under the influence of any alcohol or narcotics, and while following all traffic laws, someone falls off the sidewalk. Their timing is tragic, and you run them over and kill them. When I was coaching cross country, one of my runners, he was right in front of me, fell and sprained his ankle right into the road. I had to grab him and drag him off the road before someone ran him over. And, had someone struck him, had he fallen directly in front of the path of a vehicle, that wouldn't have been that person's fault. Knowing his mother, she would have sought vengeance. And she would have taken the matter to court anyway, even though I was there as a witness. And so if you know, that poor young man had been struck by a vehicle, I probably would have been in court. The driver would have been in court. It would have been a mess. Or even property destroyed. Property destroyed can certainly result in a civil case. You know, if someone hits your parked vehicle out there in the lot, that's not a crime. They just accidentally backed into your parked vehicle. But now your vehicle is damaged. What are you going to do? They can take you to court. In regards to accidental injury, let's say a workplace injury or death. You know, tragically, it's not uncommon for someone to die in the making of a film. So let's say that an extra dies while making a movie. There are movies that you love that people died to make. Well, that's a workplace accident resulting in death. They've had to sign liability waivers, but it's still tragic when it happens. You know, I was at a music festival and one of the road crews setting up the show had a trailer fall on him and crushed and killed him. Like, while they were setting up for the show I was going to see. They still played. The concert still went on. I'm sure a case was conducted, but no charges were filed because it was an accident. However, the family might have sued the artist or his company for damages. I don't really know what happened in that particular case. Okay, so how about loud music? Ooh, that one can get really frustrating, right? You know, if you can't sleep because of loud music, and I've had neighbors who have caused this type of problem before, it can make you feel insane, like you're not getting sleep because they're up at all hours of the night, and what are you supposed to do? You know, one scenario is you can take them to court. Okay, so civil lawsuits. Now that we're in court, how does this look? There are specific legal procedures that must be followed. You are the one seeking justice, so you are the plaintiff. You're probably going to need a lawyer unless you just know this stuff really well. I recommend getting a lawyer. And the lawyer is going to file a complaint for the court. A complaint is a formal notice that a lawsuit is being brought. So you're going to contact a lawyer. It's your first step. And they're going to file the formal complaint, which again is the first step in a formal lawsuit. Let's say you're the defendant, and I hope this never happens to any of us, but the first thing that will happen if you're in this case is you will receive a summons. A summons is a notice directing someone to appear in court to answer a complaint or a charge, and then you are legally obligated to appear in court. You may file an answer to the complaint. You know, maybe the formal summons is enough to prompt you to go work things out personally with the person. Maybe that's still an option. And so you can file an answer saying we've worked everything out, and if the plaintiff doesn't pursue it any further, case closed. But perhaps you file your answer saying you are not guilty and you're going to challenge this. Next, the complaint and answer are referred to as the pleadings. So if you are the plaintiff, you are seeking justice or restitution or whatever it is you're seeking from the court. And if you are the defendant, you are, again, seeking justice, hoping that you get out of this one. The case itself is called the discovery. Discovery is a legal term describing the process by which attorneys have the opportunity to check facts and gather evidence. So if you are the plaintiff seeking justice and you're complaining about a noise violation, your neighbors upstairs are driving you insane. Well, they're going to need to get evidence of this. I don't know. I'm sure there's a legal way they will get evidence, some kind of noise recorder or some type of device that will allow them to gather sufficient evidence that, yes, this is occurring. And so they're going to check facts. You know, if you're claiming so-and-so lives up there, They need to probably meet those people, and they need to gather evidence once more. Okay, now there's going to be a pretrial hearing where the judge is going to explain the differences between the two sides. You know, he's going to say, look, Bryce is claiming that Alan is playing his music really loud and he can't sleep and it's driving him nuts. And so that's the two sides. Alan claims that his music is being played at an acceptable volume and that Bryce is just angry at him for something else. After the pretrial hearing, the judge is going to really try to encourage both parties to work this out amicably. And perhaps they do. And maybe at the hearing, the two parties speak and agree to drop charges, in which case the plaintiff may choose to drop the case. The defendant could even offer a settlement. A settlement in a legal case is the amount of money that the defendant agrees to pay the plaintiff. A friend of mine last year was involved in a motorcycle accident. It injured him rather badly. He had a serious case of road rash, meaning like a chunk of his skin was ripped off. It took him months to recover. The driver's insurance company paid for all of his medical bills, but he wasn't satisfied. He decided to take the matter to court because not only did he receive great personal injury, but he wasn't able to work. He wasn't able to move around much. He was pretty depressed for several months while he was healing. I mean, chunk of skin off of his body. And so he was like, look, I'm suing. You know, whatever, the driver, but he carries liability insurance for that exact reason. You are required by law to carry liability insurance in case you're in an accident and you're at fault and something like this happens. And so he took the matter to court. And he, as the plaintiff, since it's a civil case, no crime had been committed, was seeking damages. And I don't remember if it was settled or what. In the case of two injured parties, or an injured party claiming that the other party caused them damage, there's a couple of ways that this can be settled. One that we use here at school all the time is called mediation. And that is, you're mad at your best friend and it's causing drama. Well, it's time for Miss Willingham or Mr. Frady to sit you two down and hear it out and let you work out your drama. And we do this, they do that at least 2 or 3 days a week, where they're dealing with mediation. And basically it forces the two parties to sit into a room together and talk to one another in a civil way. And it's the job of the mediator to facilitate that conversation. Now, trained mediators like Ms. Willingham or Mr. Frady then help the two parties find a solution. They listen, they ensure that each party has had every opportunity to talk about what's causing them grief, and then again, the goal is to find a solution. This is great if it's solved at this level, because court cases cost a lot of time and money, and no one wants that to happen. We would just like to be able to work it out. But guess what? You're not so lucky sometimes. Sometimes it goes to trial. Depending on the size of the case, it may just involve a judge. You know, if it's a case of you sold a friend a car and they can't pay you back, a judge is going to hear that. If it's a case like the Pickle-Slimer case, or Pickle-Simer, sorry, I always call it Slimer. The Pickle-Simer case in Brevard, North Carolina, had to do with an extremely wealthy family, and the kids were squabbling over the estate. And we're talking millions of dollars, and so a teacher at my school in Rosman had to actually go and serve on the jury to hear And it sounded so frustrating having to hear these rich kids squabble over their $1 million inheritances. And I'm like, yeah. But she had to go. Case cost lots of money, and it was eventually settled. The plaintiff has to present, another legal term for you, a, quote, preponderance of evidence. This means the burden of proof is on the plaintiff, the accuser. The plaintiff must present enough evidence to persuade the judge or jury in the large cases that the defendant was more likely than not to have been responsible for the incident that caused the damage. In the case of slamming the door on the girl's hand, there were witnesses. It's not just my word against hers. And so they can attest to the fact that I slammed the door on the girl's hand. Preponderance means beyond the shadow of a doubt. If the plaintiff wins, that is, if she sues me and it's proven with a preponderance of evidence that I slammed the door on her, and she wins, then a remedy is set. The remedy means that I'm going to get some money as the victim. My friend who was in the motorcycle accident, they paid his medical bills, but now he wants some money because he lost work, lost time with his family, and suffered grave personal injury. And so he's seeking a cash settlement, say $10,000 to $20,000. He's going to have scars in his body the rest of his life. I know a young person a little older than you guys. When he turns 18, he will never have to work again because he was at a restaurant as a little kid, sat too close to a heater that was an open flame heater, and it caught his clothing on fire. He suffered severe third-degree burns. His torso is now a mess of scars. And when he turns 18, the trust fund from the case kicks in, and he just wants to play Xbox the rest of his life. And he'll get to. But again, he had to suffer horrible injuries. Let's say the plaintiff lost. Let's say that, in the case of that poor young man, he suffered those terrible burns, but the court was able to demonstrate that he was just standing too close to a heater. And it wasn't a safety issue, it was a supervision one. So it's the parent's fault. Well, then the plaintiff gets nothing. And in fact, they have to pay the court cost. So look, you shouldn't be throwing around lawsuit threats all the time, because if you lose, you don't just get nothing, wasted time. You have to pay the court's time. And judges don't come cheap. Now, say that you lose. You may choose to appeal this to a higher court. We're talking lots of money at this point, but the defendant or the defendant's insurance company may appeal to reduce awards. Now, again, how do you settle a dispute? Ideally out of court, but there are other means, of course.